Question number 801. By which of the following court cannot make an order for the attachment of immovable property under Order 38 of CPC? Option A, Senior Civil Court, Court of Small Causes, District Court, High Court. Here correct answer is option B, that is Court of Small Causes. Court of Small Causes cannot make an order for the attachment of immovable property under Order 38 of CPC. Question number 802. Attachment before judgment in a suit dismissed in default revives automatically on the restoration of the suit, does not revive automatically on the restoration of suit, may or may not revive depending on the fact and circumstances of the case, neither A or B. Correct answer here is option B, that is does not automatically revive on the restoration of suit. Option B here is the right answer. Question number 803. When defendant may be called upon to furnish a security for appearance, left the local limits of the jurisdiction of the court. Option B is about to abscond. C, he has disposed of his property from the local limits of the jurisdiction of the court, and option D, all of these. Correct answer here is option D, all of these. Question number 804. The provisions regarding the temporary injunctions are contained in order of the CPC. Here correct answer is option A, that is Order 39 of CPC. Provisions regarding temporary injunctions are contained in. Question number 805. Injunction is granted under which provision of the CPC? Correct answer here is option B, that is Order 39 Rule 1 of CPC contained provisions relating to injunction. Question number 806. Interlocutory orders are issued by the civil court during pendency of the civil proceedings to summon the person for execution of decree for attachment of property. Correct answer here is option A, that is during pendency of civil proceedings. Question number 807. Temporary injunctions may be granted to restrain any election, to restrain dispossession from property, to restrain any intended disciplinary action against the public servant, to restrain the result of any adverse entry against the public servant. Here correct answer is option B, that is to restrain dispossession from property, temporary injunctions can be granted. Question number 808. Under CPC, defendant can ask for temporary injunction against the plaintiff if there appears to be a danger that plaintiff would waste or alienate the suit property, the plaintiff threatened to dispose of the property with a view to defrauding his creditors, plaintiff threatens the defendant to dispossess his from the suit property, and option D, all of these. Correct answer here is option D, all of these. Question number 809. Which of the following grounds is not an appropriate ground for the temporary injunctions under the CPC? Option A, that any property in dispute is in danger of being wasted, that the defendant threatens to dispose of his property, that the property dispute is likely to be acquainted by the government, none of these. Here correct answer is option C, that the property in dispute is likely to be acquired by the government is not an appropriate ground for the temporary injunction, whereas that a property in dispute is in danger of being wasted is a ground, and the defendant threatens to dispose of his property is also in ground for a temporary injunction under CPC. Question number 810. Civil Procedure Code provides for temporary injunction, permanent injunction, mandatory injunctions, none of the above. Correct answer here is option A, that is temporary injunction. Question number 811. Which of the following statement is incorrect? Option A, temporary injunction may be granted only at the time of the institution of suit. Temporary injunction may be granted at any stage of the suit. Temporary injunctions are regulated by the CPC. Temporary injunctions are form of a preventive relief. Here in this question it has been asked which of the following is incorrect. Incorrect answer here is option A, therefore it will be the right answer. Temporary injunctions may be granted only at the time of institution of the suit is incorrect, therefore it will be the right answer. Question number 812. What is incorrect about the temporary injunction? Option A, it finally settles the mutual rights of the parties and directs party to for all time to do or abstain from doing a thing. This provision is related to temporary injunction is incorrect, therefore it will be the right answer. Question number 813. Under which one of the following provisions of the CPC consequences of disobedience or breach of injunction has been described? Here correct answer is option C, that is Order 39 Rule 2A describes the consequences of disobedience or breach of injunction. Question number 814. Order 39 Rule 2 of CPC deals with attachment before property, temporary injunction, execution of decree, appointment of receiver. Correct answer here is option B, that is temporary injunctions. Order 39 Rule 2 of CPC deals with temporary injunction. Question number 815. According to Order 39 Rule 2A, which of the following is the consequences of the breach of injunction? Attachment of the property, detention of the person in civil prison up to 3 months, sale of the attached property after 1 year, all of the above. Correct answer here is option D, that is all of the above. Question number 816. In case of breach of terms on which the injunction was granted under CPC, the court may pass an order of attachment and sale of property, attachment of property and detention in civil prison, arrest and detention in civil prison for 3 months, A and C both. Here correct answer is option D, that is A and C both. A and C here is the right answer, that is attachment of sale of property and arrest and detention in civil prison for 3 months. Question number 817. In case of breach of any terms on which the temporary injunction was granted, the court may order: option A, the person in breach to be detained in civil prison for an indefinite period but not after the breach has ceased. Option B, attachment of the property of the person in breach, and if the breach continues for more than 1 year, sell the attached property and award the entire sale proceeds to the injured party as compensation. Both A and B are incorrect, and option D, both A and B are correct. In question number 817, correct answer here is option C, that is both A and B are incorrect. Question number 818. Attachment of property attached shall remain operative under Order 39 Rule 2A of CPC for a period of 6 months, 3 months, 1 year, 7 years. Correct answer here is option C, that is 1 year. Question number 819. Period of detention in civil imprisonment as a consequence of disobedience or breach of any injunction shall not exceed 1 month, 3 months, 6 months, 1 year. Correct answer here is option B, that is 3 months. Question number 820. Where any injunction is passed without giving notice to the opposite party, the court will try to decide the application within 7 days, 15 days, 21 days, 30 days. Correct answer here is option D, that is 30 days. Question number 821. Morgan Stanley Mutual Fund versus Karthik Das case related to which of the following? Issuance of commission, attachment before judgment, interim injunctions, affidavits. Correct answer is option C, that is interim injunction. Question number 822. Where an interim injunction has been granted without notice to the opposite party, the plaintiff fails to comply with the provisions of Order 39 Rule 3 CPC. Options are: the separate injunction lapse of the expiry of the time for compliance, the ex parte injunction would necessarily be liable to be vacated, the court can extend the time for compliance of Order 39 Rule 3 CPC even after the defendant has appeared and filed written statement. The ex parte injunctions would be vacated if the non-compliance is prejudicial to the defendant. Here in question number 822, the correct answer is option B, that is the ex parte injunction would necessarily be liable to be vacated. Question number 823. Rules 6 to 10 of Order 39 of CPC deals with attachment of property, arrest of persons, plaints, interlocutory orders. Correct answer here is option D, that is interlocutory orders. Rule 6 to 10 of Order 39 of CPC deals with interlocutory orders. Question number 824. Under which provision of CPC an order for temporary injunctions may be discharged, varied or set aside? Option R, or Rule 7 Order 39, Rule 2A of Order 39, Rule 9 of Order 39, Rule 4 of Order 39. Correct answer here is option D, that is Rule 4 of Order 39. Question number 825. Which rule of Order 39 of the court provides that an injunction directed to the corporation is binding not only to the corporation but also on all the members and the officers of the corporation whose personal action it seeks to restrain? Here correct answer is option D, that is Rule 5. Under Order 39 Rule 5 of CPC, it is provided that injunction directed to the corporation is binding not only to the corporation but also on all the members and the officers of the corporation whose personal action it seeks to restrain. Question number 826. If a party commits breach of an order of temporary injunction, A, it would be punished for the contempt of court, it would be fined, its property may be attached, none of the above. Correct answer here is option C, its property may be attached. Question number 827. A temporary injunction can be granted to a party establishing a prima facie case in his favor, balance of convenience in his favor, irreparable injury to him in the event of non-grant of injunctions, all of the above. Correct answer here is option D, that is all of the above. A temporary injunctions can be granted to a party establishing a prima facie case in his favor, balance of convenience in his favor, irreparable injury to him in the event of the non-grant of an injunction. Question number 828. In a civil suit coming up for admission, if the court does not have subject jurisdiction to grant relief in the suit, the court, option A, cannot grant interim relief under Order 39 of CPC, can still grant interim relief under Order 39 CPC, has to nevertheless issue summons of the suit, has to frame questions of law and refer it to the High Court. Here in question number 828, correct answer is option A, that is cannot grant interim relief under Order 39 CPC. Question number 829. In a suit for permanent injunction against the defendant company, the plaintiff sought an interim injunction restraining the defendant from prosecuting the suit in a foreign court. Options are: temporary injunctions can be granted restraining the foreign court from proceeding the suit. A temporary injunction restraining the foreign court can be granted if there is a prior pending suit in India, irrespective of where the defendant resides or carries on business. Option C, a temporary injunction restraining the defendant for prosecuting the foreign suit can be granted if the defendant is amenable to the jurisdiction of the court, and all of these. Here in question number 829, correct answer is option C. A temporary injunction restraining the defendant from prosecuting the foreign suit can be granted if the defendant is amenable to the jurisdiction of the court. Question number 830. An order passed under Order 39 Rule 1 of CPC can be challenged by filing an appeal, a writ petition, a revision petition, none of these. Correct answer here is option A, that is an appeal. An order passed under Order 39 Rule 1 of CPC can be challenged by filing an appeal. Question number 831. Under which order of CPC provision relating to appointment of receivers has been provided? Here correct answer is option A. Order 40 Rule 1 provisions relating to appointment of receivers has been provided. Question number 832. The court may order to appoint a receiver to any property before a decree where it appears to the court to be just and convenient, where the sued property is in danger of being wrongfully sold in execution of a decree, where the defendant is about to dispose of the whole or any part of the property, where the defendant has ascended the local limits of the jurisdiction of the court. Here correct answer is option A. Where it appears to the court to be just and convenient, the court may appoint a receiver for any property before a decree. Question number 833. A person who is appointed to protect the disputed property is known as, options are a judgment debtor, commissioner, receiver, pauper. Here correct answer is option C, receiver. Question number 834. A receiver is an officer of the court, agent of the plaintiff, agent of the defendant, either agent of the plaintiff or defendant. It depends on the circumstances. Here correct answer is option A. A receiver is an officer of the court. Question number 835. Appointment of receivers of any property can be made when? Before decree, after decree. Only appellate court can made order. It appears to the court to be just and convenient whether before or after decree. Here correct answer is option D. It appeared to the court to be just and convenient whether before or after decree. Appointment of receivers any property can be made. Question number 836. Under which provisions of the Code of Civil Procedure a collector may be appointed as a receiver? Here correct answer is option A, that is under Order 40 Rule 5 collector may be appointed as receiver. Question number 837. In how much time respondent may file cross objections for the day of service of notice of the hearing and appeal? Here correct answer is option B, that is in 1 month. Question number 838. Every appeal shall be preferred under the Code of Civil Procedure in the form of dash signed by the appellant or his pleader. Here correct answer is option C, that is memorandum signed by the appellant or his pleader. Question number 839. If in an appeal from a decision by the trial court, the appellate court finds that certain necessary evidence was not taken by the trial court, the appellate court, option A, can only remand the matter to the trial court for taking additional evidence, shall decide the matter only on the basis of the evidence before it, shall presume that the missing evidence would have adversely impacted the case of the property who should have brought that evidence, make additional evidence itself. In question number 839, correct answer is option D, that is may take additional evidence itself. Question number 841. Which one of the following statement is not true in relation to the power of appellate court under Code of Civil Procedure? Option R. It can determine a case finally, it can remand a case, it cannot take additional evidence, it can frame issue and refer them for trial. Here correct answer is option C, that is it cannot take additional evidence is not true in relation to the power of appellate court under CPC, but it can determine a case finally and it can remand a case, it can frame issues and refer them for trial are the true propositions and related to this question. Question number 842. Order 42 of the CPC deals with appeal to Supreme Court, appeal by indigent person, appeal against orders, appeal from appellate decrees. Here correct answer is option D, that is appeal from appellate decrees. Question number 843. Under Order 43 of CPC against which order and appeal shall not lie? Option A, an order to set aside or refusing to set aside a sale. Option B, an order rejecting an application for permission to sue as an indigent person. Option C, an order on an objection to the draft of a document. And option D, when the subordinate court has exercised its jurisdiction illegally or with the material irregularity. Here in this question it has been asked under Order 43 of CPC against which an order and appeal shall not lie. Here correct answer is option D, when the subordinate court has exercised its jurisdiction illegally or with material irregularity, then on this order an appeal will not lie. Question number 844. Against which of the following order an appeal shall not lie under CPC? Option A, an order for return of plaint under Rule 10 of Order 7 where the procedure of Rule 10A of Order 7 has been followed. B, an order in interpleader suit under Rule 3 of Order 35, an order of refusal under Rule 19 of Order 41 to readmit an appeal. And option D, an order under Rule 4 of Order 47 granting an application for review. Here in question number 844, correct answer is option A. An order of return of plaint under Rule 10 of Order 7 where the procedure of Rule 10A of Order 7 has been followed. In this case, the appeal shall not lie in CPC. Question number 845. An appeal under Order 43 of CPC shall lie from which of the following orders? Rule 11 of Order 7 rejecting the plaint, Rule 9 of Order 22 refusing to set aside the abatement or dismissal of the suit, Rule 1 of Order 8 not permitting the defendant to present the written, Rule 5 of Order 14 refusing to strike out the issues at the instance of either of the party. Here correct answer is option B, that is Rule 9 of Order 22 refusing to set aside the abatement or dismissal of the suit is the correct answer. Question number 846. Pauper appeals have been provided under. Correct answer is option C, that is Order 44 of CPC. Question number 847. If the court is satisfied that a case pending before it involves a question as to the validity of any act, the court should decide the validity of act, refer the matter to the High Court. High Court should exercise power to revision, refer to the Supreme Court for advice. Here correct answer is option B, that is refer the matter to the High Court. Question number 848. Section 114 of CPC should be read with. Options are Order 46 Rule 1, Order 47 Rule 1, Order 47 Rule 3 and Order 41. Here correct answer is option B, that is Order 47 Rule 1. Section 114 of CPC should be read with Order 47 Rule 1. Question number 849. The grounds for review have been provided under. Option A, Order 47 Rule 1 of CPC, Order 42 Rule 1 of CPC, Order 43 Rule 1 of CPC, Order 44 Rule 1 of CPC. Here correct answer is option A, that is Order 47 Rule 1 of CPC. The grounds of review has been provided under Order 47 Rule 1 of CPC. Question number 850. Under the CPC, when application for review is dismissed, appeal can file against the order. No appeal lies. With the permission of the court, appeal can be filed against the order. None of them. Here correct answer is option B, that is no appeal lies. When application for review is dismissed, no appeal will lie.